Question: unsa may mga things or things to note about land registration proceedings? I will give you a few tips or a few notes from the Supreme Court case that I gathered. Kaning land registration proceedings, normally this is known as land titling proceedings, pa-titulo ba? Pa-titulo sa yuta. So before we answer the question, hi, I'm Attorney John Edmond Ruz, and you are listening to our show, Hold Your Ground. Sa atong show, we spend a few minutes of the present. We gather lessons from the past, from the Supreme Court cases, as an investment for our future. So, in a Supreme Court case, ningon ng court, in land registration proceedings, ang applicant na i-burden para pag-prove sa iyahang private ownership nga dili na siya panag-iya sa government. In land registration proceedings, the applicant has the burden of overcoming the presumption of state ownership. Meaning, gikan sa pagka public part of the public dominion, panag-iya sa state, imo siya ibalhin into private ownership. So, ang applicant must establish through incontrovertible evidence, tataw ug klaro nga ebidensya nga kaning yuta nga gusto nato iparehistro, meaning patituluhan, part of the torrent system registered under our titling system, is in fact alienable and disposable based on a positive act of the government. So there must be a certification, naani siya certification nga i-form part sa evidence that the land that you want to be titled is alienable and disposable. It can never be a valid title when you will be applying for a title over a certificate over a certain parcel of land nga ang kaning yuta forest land or timberland. So dili gyud na siya feasible. Okay, so kaning naay case dire, nga once ang landowner na tagaan na siya og titulo sa yuta, it is presumed nga na-overcome na to niya ang presumption that the land sought to be registered forms part of the public domain. Pasabotan ni, kanang imong yuta, generally, kung walay titulo, dili klaro nga private ownership na siya, meaning, panag-iya na siya sa Republic of the Philippines. But, if kaning imuhang yuta, ma-prove gali nimo nga private property na siya based on the grounds provided for by law, so mahimo na gani siyang private property, mo na siya imong convenient proof kana imong titulo, meaning na overcome, presume, dili na nimo kailangan i-prove pa, presume na siya kung nakititulo nga na-proven nimo nga kaning yuta na ay kanang outside na siya sa public dominion, dili na siya panag-iya sa gobyerno, but it is already considered as private property. Okay, so pero if ever na may panahon nga forest land, timberland na patituluhan, it would not mean nga ang gobyerno wala na remedy, wala na siya solusyon. The government can always file a case for reversion. So in the next video, we will tackle more about this action for reversion that will be filed by the government against certain landowners who had caused the issuance of a certificate of title or had the land registered even if the land should not have been titled in the first place. For example, imong yuta, imong gipa-declare as private property even if ay imong ipa-declare as alienable and disposable even if it is really part of the forest land. So dili na mahimo. So the state, the government has the remedy by filing an action for reversion, meaning ipabalik ang yuta from a private property classification, ibalik ni siya to form part of the government's property, no? The public dominion. So we will discuss this further in the next video. Before you leave, if you like our video, please like our page and click the subscribe button. Thank you.